I'm Kim Rathbone with Rathbone Group, and this is On Subrogation. Today I'm in DC at the NASP 2019 Annual Conference, and I'm joined here by Susan Benson, who's an attorney in California. Thank you for joining.
Thank you for having me, Kim.
So Susan spoke today on out-of-pocket damages, and we asked her to join. Thank you for doing that.
Yes, it was a really good topic. We actually called it Oops, I Did It Again. And we say that because oops are out-of-pocket damages. So when we have subrogation claims, there are claims that are paid by the carrier. And then, of course, you have the out-of-pocket claims that are not paid by the carrier. And it has become a huge issue. 20 years ago, it was not a huge issue. We'd make a subrogation claim, we'd get a check, and we didn't care about what the insured was doing. Now, because policy limits are so small, they haven't changed in years. California, New Jersey, Pennsylvania, and Massachusetts have a $5,000 policy limit. So when you get in an accident, you know, the damages are usually more than the $5,000. So the question becomes, how much does the insurance company get, and how much should the insured get if there's an out-of-pocket claim?
Right. And so give some examples of out-of-pocket claims.
Okay, so under your insurance policy will usually cover you for the repair of your vehicle, sometimes the rental of another vehicle, and you also incur a deductible. So that deductible is an out-of-pocket damage. You may not have rental coverage, so that is now an out-of-pocket damage. Another huge out-of-pocket damage, and which has become a big issue, hot topic in the past few years, is called diminution in value. And what that means is that your vehicle is worth so much before the accident, and then you have the accident. Even if it gets repaired, it's never going to be worth the same in some circumstances. So there's this diminution in value claim. What was the effect on that accident? And how much is the value of that vehicle even with the repair? And most insurance companies do not provide that coverage.
So how do you figure out whether there's an out-of-pocket claim involved or not?
Well, in the adjustment level, it's probably the easiest. They're the ones that are talking with the insured every day, or talking to adjust the claim, helping them find a repair facility, hooking them up with a rental car company if they have the coverage. But if they don't, that's such an opportune time to say no rental coverage, and then ask the insured, are you going to be renting a car? Perhaps they have another car that they will use and not make a claim, although they might be entitled to. But a lot of questioning by the adjuster is prudent at that early stage.
And so what type of communication would you suggest should happen with the insured then, and then later on subsequently, maybe after the claim is resolved?
Well, you're in constant, well, I wouldn't say constant, but you are in communication on the adjustment level because you have to adjust the claim within certain time periods under most state statutes. By the time it comes to the attorney to pursue that subrogation claim, you don't have that benefit if that legwork hasn't been done. So what the attorney should do immediately upon the referral is send out a letter to the insured and say, hey, we've been retained by your insurance company and we are pursuing reimbursement of what your insurance company paid, including your deductible, because most state statutes require us to do that. Here's where the confusion comes in. We may be pursuing their deductible, but we're not pursuing their out-of-pocket. We don't have standing to do that because the insurance company didn't pay the claim.
So do you want to explain why you can pursue the deductible but not other types of out-of-pocket claims?
Sure, that's a good question. Most state statutes require an insurance company to include the deductible in any demand, which they do. And when they negotiate a settlement, that deductible is reimbursed in accordance with the insurance policy. By the time it comes to us, the attorney, we still request that. But in essence, if we end up filing suit, we have to actually get an assignment from the insured to pursue that, which usually is never a problem because the insurance company is in a better position to file suit, spend the money, and get the insured's deductible back. Out of pocket is a different ballgame. Out of pocket damages are not fully ascertainable for most situations. In particular, a diminution in value claim. Most jurisdictions will require an expert's report to show what the value was before and after. And there's really no obligation on the insurer's part to provide that courtesy to the insured. It's the insured has an affirmative obligation to pursue those damages on his own.
And what happens when there's a release involved for either party?
This has recently become a huge issue. Like I said, in the early days, we wouldn't have to sign a release. But when there is a release, particularly when a policy limit's involved, first, from the viewpoint of just settling a case, I've got my attorneys looking at a case where there's a $5,000 minimum limits. The case is $12,000. I'm going to try to get 100%, of course. But what is 100% if I don't know how much I'm getting from the policy limits? That's why it's so important to know what the out-of-pocket damages are. Once I find that out, let's say the insured has a $300 rental. So I know I'm going to get $4,700 from this $5,000 policy limit. I get contribution payments from the individual. I'm ready to sign a release. And then the other carrier says, well, your insured hasn't returned their release. I'm thinking maybe they have more out-of-pockets, maybe they're not satisfied. So the question becomes, what do we do in those instances? We reach out to the client. The client, sometimes is the best person to contact the insured to say, hey, you have a duty to cooperate under the policy in order for us to obtain reimbursement or recovery, and that doesn't mean you have to sign a release for your out-of-pockets. It does mean you have to give us your cooperation. If I can't reach the insured that way, I look through the log notes and I look for an agent's name. The agents are the ones who know insureds personally. They're not a claim rep from the subrogation department, and no offense to them, we love them. But they haven't had conversations with the insured. They don't know their background or their family or their history. So getting an agent to really help us out is priceless, and we've used it a lot in the past. If we cannot get an agent to help, or if the agent just can't locate the insured, or the insured has gone on and is represented by another carrier, there's issues there. Sometimes it's just a matter of waiting till the statute of limitations run to know that when we sign a release, we're not affecting our insured's rights. That's our biggest concern. If we sign a release for all property damages arising out of this claim, will it affect the insured's rights to go to request, their damages? So.
Do you have suggestions for language that could be included in the release of the insurer?
I sure do. And, when I say that we have to wait for the statute to run, these are in situations where the other carrier will not take a revised release. So in the instances where the other carrier is receptive to it, we will say, look, we agree to accept this sum as full and final settlement of all subrogation claims. However, it does not affect any rights of our insured to pursue any out-of-pocket claims or uninsured losses arising out of this incident. We'll also add, however, we will reimburse the deductible in accordance either with the state statute or the policy.
It's surprising to me that sometimes that is an issue and that they're not as receptive, because it's a very reasonable thing to want to address, especially when you can't represent the insured at the same time as the carrier.
Well, in these matters, it's when there is a policy limits problem. And if they give me all of their limits, they're exposing their insured to an amount above those limits. But in most respects, look, if we can't find our insured, we've already reached out to the other carrier saying, one, did they make a claim? Usually they haven't. Have you been able to talk to them? No, we haven't. What are the chances of the insured actually filing suit for those out-of-pockets? So, it's a risk on their part, but they've also minimized the exposure to their insured on our claim in many respects, and the insured's claim.
Yeah. Well, thank you so much. I enjoyed your presentation today.
Thank you very much.
And thank you for joining us. Yeah,
It's a pleasure being here.
it.
Thank you.
And this is On Subrogation. Again, I'm Kim Rathbone, and this is Susan Benson. That's the long and short of it.